Well, I'd like to thank Senator Daschle again for those wonderful remarks. And I would anticipate that certainly some of the themes that Senator Daschle brought up will echo in the upcoming discussion. I have the honor now of introducing the moderator for this afternoon's panel, Julie Rovner. You have handouts that have the details of Julie's background and today's panelists, but I will mention a few things to you. When you hear Julie speak, she will be instantly recognizable. She is the health policy correspondent for National Public Radio, and at NPR has specialized in the politics of healthcare and was awarded the 2005 Everett McKinley Dirksen Award for distinguished reporting on Congress for coverage of the passage of the Medicare prescription drug legislation. She's appeared on numerous television shows and in countless publications. And she is the author of a critically acclaimed reference book, Healthcare Politics and Policy A through Z. Now, before I turn it over to Julie and for her to introduce the panelists, I did want to mention one ACS update, which is that we have a new page on our website, which I hope you will go to, which contains the legal filings from the cases dealing with healthcare, news stories, videos, and many other resources. So I hope you will go to our website and take a look at that for further information. And now we'll turn it over to Julie.
I want to thank you, and really I want to thank Judge Vinson for not issuing his clarification this morning so I could be here. That was why I was checking my phone. I was not playing Angry Birds. So far, we have not heard anything. Find my... Well, thank you for joining us. I am honored, and I have to admit, a little bit excited to be here today, hoping to get some of my own questions answered about the ongoing litigation that I am following perhaps a bit more closely than I had anticipated maybe, a few months ago. As someone, and I guess the only one on this panel who is not a lawyer, but who took constitutional law in college as an undergrad, I know just enough about all of this to be dangerous. I also know that our speakers are extremely impressive. So without further ado, I will introduce them. You have their bios, so here is the abridged version. Walter Dellinger, who is immediately to my right, is or should be familiar to anyone who follows constitutional or Supreme Court politics. He currently chairs the appellate practice at O'Melveny & Myers and is a visiting professor at Harvard Law School. He's a former assistant attorney general in the Clinton administration, served as acting a solicitor general in 1996 and 97. He's argued more Supreme Court cases than we can recount here and written even more journal articles. Elias Soman is an associate professor at the George Mason University School of Law. He's to Professor Dellinger's right. His research focuses on constitutional law, property law, and the study of popular political participation and its implications for constitutional democracy. He serves as co-editor of the Law and Economics Journal, the Supreme Court Economic Review, and he's also written for a long list of other scholarly and lay publications. He's also intimately familiar with the subject at hand. He wrote the amicus briefs in 2 of the individual mandate cases on behalf of the Washington Legal Foundation and a group of constitutional law scholars. To his right is Simon Lazarus. He's public policy counsel for the National Senior Citizens Law Center. He worked on Jimmy Carter's domestic policy staff and later for the law firms Powell, Goldstein, Frazier, and Murphy, and Sidley Austin. I would also note that he has written on the subject we are discussing today for the American Constitution Society. And finally, last but certainly not least, Neera Tandon is Chief Operating Officer for the Center of American Progress, our host for today's program. Before rejoining CAP, where she was one of its founding senior staff members, Neera was Senior Advisor for Health Reform at the Department of Health and Human Services, where she worked to develop the law that is the subject of our discussion here. Along the way, Neera also worked on the Obama campaign, the Hillary Clinton campaign before that, and in the Clinton White House. And she knows a little something about the law, too. She is a graduate of Yale Law School. So here is how we will proceed. Professor Dellinger will begin with a short discussion of why he believes the Patient Protection and Affordable Care Act is constitutional. Professor Soman will follow with his discussion of why he believes the opposite. Following that, Simon Lazarus will update us on the status of the various lawsuits now wending their way through the courts. There are more than just the 5 that you've heard about. I actually have an Excel spreadsheet and still can't manage to keep track of them, so I'm particularly looking forward to that. Finally, Nero will back cleanup and talk about the challenges the litigation is posing for implementation of the law. After that, we'll have 20 minutes or so of discussion here amongst the panelists. Then we will open it up to questions from the audience. When we get to questions, I would ask that you please identify yourselves. This is being webcast. So with that, let's begin. I will use my trusty iPhone stopwatch to keep track, and I will let each of you know when you have a minute left, and I'll remind you that you each have 7 minutes. So, Professor Dellinger?
Thank you, Julie. The issue of the constitutionality of the individual health care mandate was recently resolved in the 1820s by Chief Justice John Marshall, who wrote that the Commerce Clause confers upon Congress the power to regulate that commerce which concerns more states than one. This regulation concerns commerce that affects 1/6 of the national economy. And the notion that this congressional regulation of the interstate market in healthcare insurance, a regulation which is essential to the extraordinarily large interstate market in healthcare, the assertion that Congress lacks the affirmative legislative authority to regulate these markets is a truly astonishing proposition. Charles Freed, who served as Solicitor General under President Reagan, testified with me before the Senate Judiciary Committee, and Charles says it's so simple. In 1944, the Supreme Court confirmed in Southeastern Underwriters, United States versus Southeastern Underwriters, that, of course, Congress has the power to regulate the interstate insurance market. This is a regulation of the market. It imposes an affirmative obligation, but it imposes one on a group that is almost certain to use the healthcare system and is therefore, in addition to being simply a regulation of the interstate insurance market, in addition, separately and independently, it is a regulation of a healthcare market where indisputably Congress can tell interstate insurance companies that they cannot deny coverage because of pre-existing conditions, because of the health care of a child, because you have a child born with a birth defect. And as part of that, it can provide a financial incentive for people to participate in that market. It's undoubtedly a regulation of commerce. The question is there something so novel, unprecedented, extraordinary, and intrusive about this regulation that we have to carve it out of what would normally be Congress's authority? And the answer to that is surely no. It is no more intrusive than Medicare or Social Security. If you enter the work which you're adopted under the taxing power and not the commerce power, but nonetheless, the point is there's nothing extraordinarily intrusive about this. If you go to work in the national economy, and those are the only people to whom the individual mandate penalty applies, you have to go to work in the national economy, earn a minimum amount, $18,000 for a couple, in order to have to file an income tax return where you have to pay a 2.5% penalty if you haven't maintained minimum health care coverage. Those people find out they have to pay 7.5% in Social Security tax to take care of subsistence in their old age. They have to pay a lesser percentage for Medicare in order to take care of their health needs after they're 65 years old. And they have to pay a 2.5% surcharge on their income tax unless they've maintained minimum insurance coverage. No one is going to hear that when they go to work and say, oh my God, that third one means it's the end of liberty as we know it. It is no more intrusive than the others, and less so in that, unlike Medicare and Social Security, it provides a choice and utilizes the free market alternatives. That's why it was always the more conservative approach to providing health care. And why I think at the end of the day, Chief Justice Roberts will be in the majority to uphold this. He is thinking of a very long philosophical position as a Chief Justice, and he would not want to adopt a principle that said that 25 or 30 or 40 years from now, the only way Congress could deal with a social problem is by providing a monolithic, single, governmental, bureaucratic approach, rather than creating incentives for people to utilize choices within the free market. Why would someone want who has grown up and with conservative principles want to adopt that, which would be essentially what you would have to hold in order to strike down the mandate. The only arguments against it are that, the only other argument against it, apart from its extraordinary intrusiveness, which I think is belied by Social Security and Medicare, is the notion that there will be no limits. And the idea is if you can regulate, quote, inactivity, that's got to be the end of the horizon. You have to regulate anything. That's crazy. No one has ever thought of the imposition of affirmative obligations when that is done as part of a power that Congress has to regulate the militia, to regulate commerce under any of its other authorities. No one has ever thought of imposing an affirmative obligation as regulating inactivity. When the Congress in 1792 said everyone has to have a musket, ammunition, and a knapsack, no one said, oh my goodness, that would be a regulation of inactivity, and if we could do that, we could do anything. No, you're exercising the militia power. Finally, I think there's no problem setting limits. None whatsoever. You can simply say that Congress has the power to create an incentive to purchase a product to maintain coverage, where you have facts like these, where there's going to be no assurance that you won't be resorting to this, and where you do, a substantial part of the cost will be transferred to others. There's nothing else like that. If I don't provide my own flat screen television, and my team surprisingly makes the Final Four, there's no emergency flat screen television act. I don't get to go to Best Buy and say, you have to provide me with a flat screen television and impose the cost on other customers. There's no product like that. You can uphold a phone book, Yellow Pages, with 3,000 goods and services. There's no other product like healthcare. And what the court will say is we need not accept any notion that Congress can create an incentive to purchase products in order just to stimulate the economy, because here 94% of the uninsured have actually used the healthcare system. 1/3 of the medical cost of the uninsured are borne by the uninsured. The rest are passed on to others, and only 10% of the hospitalization cost of the uninsured are borne by the uninsured. 90% of the hospitalization costs are transferred to other persons who are sick or to taxpayers. There is no other product like that. So it's clearly within Congress's commerce power. It approaches no limits and does not start sliding down any slippery slope. And at the end of the day, I think the court will write, as Justice Benjamin Cardozo said in a different context. Cardozo wrote, whether wisdom or unwisdom resides in the scheme of the statute in question is not for us to say. The answer to such inquiries must come from Congress, not the courts. Our concern here is often with power, not with wisdom. That's Justice Cardozo writing for the court 75 years ago, upholding against similar constitutional attack the Social Security Act of 1935. Thank you.
Thank you. Professor?
Thank you very much to ACS for organizing this event and for my co-panelists for participating. I think the key point that I want to make today is that there is no logical way to uphold this individual mandate except by a chain of reasoning that would allow Congress to impose any other mandate of pretty much any kind. And that is a power that is not consistent with the way the Constitution is written, and it's also a dangerous power for Congress to have, even if we feel, well, it's not dangerous when our political allies are in power. I think the events of the last few years have shown that control of Congress can change very quickly and also very often. So I'm going to talk briefly about the three different ways in which the federal government argues that this mandate is constitutional under the Commerce Clause, which Walter mostly focused on, and then also more briefly under the Tax Clause and the Necessary and Proper Clause. So I'm going to start the discussion of the Commerce Clause by doing something that most law professors rarely do, which is to talk about what the Constitution actually says. And the text of the Constitution says that the Commerce Clause gives Congress the power to regulate, quote, commerce among the several states. So just looking at that text, it seems that for something to be a regulation permissible under the Commerce Clause, it must regulate commerce, and that commerce has to be interstate. Now, when we look at the individual mandate, it scores 0 for 2 on that simple two-pronged test. In particular, not having health insurance is not commerce, and even if it somehow is commerce, it's also not interstate. Now, this sort of common sense textualist interpretation of the Commerce Clause, I think, is quite consistent with the overall structure of the Constitution, because if you instead interpret the Commerce Clause to give Congress the power to regulate anything that might have some economic effect, that would render most of the rest of Article 1 of the Constitution redundant. For instance, the very same phrase of the Constitution, which gives Congress the power to regulate interstate commerce, also gives it the power to regulate foreign commerce and commerce with the Indian tribes. Obviously, foreign commerce clearly affects interstate commerce, so there would be absolutely no need to give a separate power to regulate foreign commerce if, in fact, the power to regulate interstate commerce gives Congress the power to do anything that might have some sort of significant economic effect. This is also the way that the Commerce Clause was interpreted during the first 150 years of American history or so. Walter mentioned the 1824 case of Gibbons versus Ogden. Well, if that case resolves the present one, and as Walter suggested, it's not in a direction that Walter would want, because in that case, Chief Justice Marshall actually gave us a long list of things which are not covered by the Commerce Clause, and one of them, he said, are, quote, health laws of every description. It seems to me that the current law falls under the category of health laws of every description. I don't think you have to be a lawyer to see that. Maybe Chief Justice Marshall was wrong, but if he was right, then it doesn't bode well for this particular case. Now, I fully recognize, of course, that since the 1930s, the Supreme Court has expanded the scope of the Commerce Clause far beyond its text and original meaning. However, even the court's most extreme and most expansive decisions in this area all shared a common characteristic. That is, they all involved regulations of some sort of pre-existing economic activity. We can go case by case later, perhaps, if people are interested. There's not time for it now, but every single one of those cases shared that characteristic. So therefore, if you want to go beyond that, then there's no coherent way to do so without allowing virtually any mandate of any kind, because pretty much any mandate, especially any mandate to purchase any product, will have at least some significant economic effect. Now, perhaps recognizing this problem, the federal government has argued, as did Walter just now, that healthcare is special. One way they say that healthcare is special is that we all use it at some point in our lives, which is not true of most other products. Notice, however, the bait and switch here. No one denies that not everybody will use health insurance, so the focus is switched to health care. Once you make that switch, you can justify any mandate of any other kind as well. For instance, consider the famous broccoli mandate. It's true, not everybody likes broccoli as I do, so not everybody will eat it regularly the way that I do. However, everybody does eat food and participate in the market for food, so you can justify a mandate to buy and eat any kind of food whatsoever just by switching the focus to food from broccoli or what have you. Indeed, you can even have a health rationale for it. After all, eating healthy food improves your health, probably reduces insurance costs, according to many studies, even more so than any kind of health insurance reform could do so. You can make the same kind of argument for any other mandate to purchase just about anything simply by shifting the focus to a broader kind of market. Now, the second and more recent argument that has been deployed along these lines is say, well, healthcare is different because in some situations, providers are required by the government to give free service, but it's never explained why this difference is constitutionally significant. The reason, presumably, is that this has an economic impact on healthcare providers, but of course, any failure to purchase anything also has such an economic impact. If fewer people purchase cars, that can have an enormous impact on the auto industry, and indeed has over the years, as we've seen recently. So this is not ultimately a principled legal line that a court is likely to draw. I want to go on briefly talk about the tax clause. The argument that is made here is simple. It is said that this is a tax because you have to pay a monetary fine if you violate the healthcare mandate. All 4 courts that have considered this issue so far have disagreed and said this is a penalty, not a tax. I think that's correct. If it were not correct, you could impose any kind of mandate to do anything so long as the punishment for violating it were a fine. I would note that I'm not the first law professor to suggest that this is a penalty, not a tax. A more famous professor, Professor Barack Obama, said the same thing a couple years ago when he said for us to say that you've got to take responsibility to get health insurance is absolutely not a tax increase. I think he was absolutely right about that, and I hope the government's lawyers will switch their position to the White House's position on this issue. Finally, the necessary and proper clause, I think the important thing to note about the clause is that in order for something to be valid under it, it's not enough for it to be necessary, it also must be proper. And if the word proper means anything, it means that Congress does not have unlimited power to impose virtually any kind of mandate and does not have unlimited power to interpret the Constitution in such a way as to make most of the rest of its powers redundant. And so I think there's a pretty strong case that if anything is improper, it is a law that can only be upheld by logic, which would give Congress the power to mandate pretty much anything of any kind. I would close with this, and that is that it's easy to make fun of slippery slope arguments and say, well, that would never happen. This slippery slope of having numerous mandates of various kinds is much more plausible because we know that this town is filled with special interest business lobbies and others who would be very happy to lobby for the opportunity to get a mandate to force people to purchase their products. Notice that at least in part because of a deal with the health insurance industry, this particular mandate was created even though in the 2008 campaign, President Obama, then Senator Obama, inveighed against the idea and said that it was terrible and oppressive. So on that note, I close, and I very much look forward to the questions and discussion. Thank you very much.
Thank you very much. And before we move on to our update, I have an update to the update, although I don't have, there's an app for Pacer. I don't have it yet, but we are told that Judge Vincent has indeed issued a stay of his ruling. So he has clarified that he did not intend, he intended for he did not need an injunction because I guess he did not intend for he intended for his ruling not to take effect immediately. At least that's what we will find out, I guess, shortly. But given that, we will now move on to Simon Lazarus, who will tell us the rest of what's going on with the various lawsuits.
Yes, that's certainly the most important thing that's going on. There are something like 22 lawsuits. There are more than 2 that are important, but there aren't, I don't think there are really anything like 22. Appeals have been filed to the Fourth Circuit in 2 of those cases, and to the Sixth Circuit in 1. The oral arguments are scheduled for April and May, and the plaintiff conservative advocacy group whose case was dismissed by Judge Kessler here in the district a couple of weeks ago has filed an appeal and a request to have the case en banc from the beginning, obviously thinking that they will have a certain majority of appointees of their political religion on such a panel. So I think that's really the status update, plus what Julie just told us. My understanding from glancing at Nira's BlackBerry is that the judge has stayed his decision for 7 days to give the Department of Justice a chance to seek an appeal and obviously a longer stay from the 11th Circuit. So that, I think that's really all we know, which doesn't necessarily mean that Judge Vincent has been as self-effacing as he might seem at first blush, which is not terribly surprising based upon his prior decisions in this case. I want to just focus on the real world and not all of the very elaborate legal arguments, and I would congratulate Elia on this occasion as well as the other occasions I've had the privilege of being on panels like this with him, of elaborating the legal arguments against the mandate with great precision and effectiveness. But let's look at what is practically at issue. What is at issue within the extraordinarily comprehensive description of what the actual policy program that is at stake is that Senator Daschle outlined earlier. And what is at issue, I think, here is, does the Constitution that the framers wrote prevent the Congress of the United States, the people of the United States and their elected representatives, from ensuring that people who have pre-existing medical conditions have access to affordable health care and health insurance? Does our Constitution prevent Congress from trying to do that? As Senator Daschle pointed out, it's taken many, many years, decades, for Congress to get its act together to be able to do that. And are we now being told that our Constitution says, no, no, Congress, you can't do it? The Constitution, as it has been interpreted, at least for the last 75 years, and actually, Ilya, by Chief Justice Marshall, who was, after all, a contemporary of the framers and should be presumed to have a better idea of what they intended than any of us do, such a decision would really be quite unthinkable. Such decisions are clearly up to the elected representatives of the people and not up to life-tenured, unelected justices. And I think that is really what we're looking at here. And I'm not really exaggerating, because what the opponents of the constitutionality of the mandate are contending, remarkably enough, is that they will concede, or at least most of them will concede, that Congress could require universal contributions to the health care insurance system by way of expanding Medicare to all adults or some other single-payer government-run system, which is a rather odd position for conservatives to take, but there it is. They've also conceded in oral arguments other options, such as forbidding providers to serve people who need treatment if they don't have insurance, an option which is laughable because our society doesn't work that way. There other options have been discussed to the mandate, such as the idea of having automatic renewals or a negative option for enrollment. But the closer one gets to a system that actually is effective and actually is effective in inducing all people who can afford it to get insurance, the closer one gets to the mandate in practice, and therefore its validity will be disputed under any ruling that the mandate itself is unconstitutional. So the real question is, does the Constitution put the people of the country and Congress in a straitjacket like that? That's the practical, real-world question. I am pretty confident that a majority of the Supreme Court is going to say that it isn't. But I would like to spend some moments. How many moments do we have left,
You have
Julie?
about a minute and 15 seconds.
About a minute. Just trying to look at the other side of the coin, and that is, what will the constitutional landscape look like if Ilya's position is upheld by the Supreme Court? So I'd like to look at that quite specifically. We should all understand this, that if the mandate is ruled unconstitutional, and if the arguments that the opponents have mounted are upheld by the court, we are looking at the certainty of copycat follow-on lawsuits of all kinds challenging myriad major programs that the whole country takes for granted. So let's just take a real quick run through some of these possibilities. First of all, the opponent's argument eliminates, for all practical purposes, the necessary and proper clause as an independent source of congressional power from the Constitution, which is at odds with Chief Justice Marshall's jurisprudence and certainly the post-New Deal jurisprudence. We really have no way of knowing what collateral damage that principle would proliferate throughout the structure of legislation in this country, because there's never been any, it's completely radical. There aren't any cases that are close that we could say would go the other way. But it would be considerable, and lawyers for business interests and other interests would be quite creative immediately in finding things to challenge under that. Secondly, the distinction between activity and inactivity, which is just a factual difference and provides no real basis for changing the applicable legal standards here, but if it is elevated, as they wish to do, to a legal standard, then there's no question that there will be challenges to workplace anti-discrimination laws, and there will be challenges, at least as far as I can see here, to environmental laws which impose liability, for example, on homeowners or property owners who haven't, quote, engaged in any real activity. Certainly people in that situation, in both those situations, will often have engaged in something in less activity than people who are uninsured in the real world health marketplace, but have, for example, used the health, have sought medical treatment, as 94% of uninsured people have. Thirdly, I think the most dangerous long-term principle, and I'll just briefly state this, Julie, because I don't want to run over my time.
You're over.
Has enough problems with the way he's outnumbered already. Is just basically these theories reinstate under the Commerce Clause the idea that any kind of undefined liberty interest can trump an otherwise valid regulation of commerce that was the hallmark of the so-called Lochner era, the first third of the 20th century, and was, we thought, interred forever in 1937. And it really just brings this whole idea back that, you know, a judge can decide that there's a liberty interest here that is important, and therefore we can junk some important statute that Congress has enacted to regulate commerce and actually anything else. That principle will endanger environmental laws, lots of other regulatory laws, and ultimately, it endangers mandatory contributions to governmentally mandated government insurance funds such as Medicare or Social Security. So I will leave it at that.
And finally, Neera.
Great. And
implementation?
So I will only speak briefly because I think it's important to get to questions. But I think what's most important is that we have the news that we just had, which is that the Vinson decision has actually been stayed. And why I think that's so critical for my part of this discussion is that in terms of threatening implementation, that was the decision by Judge Vinson originally a few weeks ago was the greatest threat to implementation because it just created a level of uncertainty. And I think it is extremely noteworthy that really the most conservative judge who chose to, given determination about the individual mandate, throw out the entire legislation when confronted with a set of facts about the implications for states, businesses, and the American people for that decision, chose to stay his own decision to await appellate review. So I think that is very important and noteworthy and speaks, at least to some degree, to the fact that we are seeing that a number of Americans have actually already benefited from the law. And I would just, Senator Daschle went through this, and so I will speak briefly about the benefits of the law and how we were conceiving of implementation when the law itself was developed. It really is in two phases. And speaking very broadly, there's really two large phases to the legislation. There's phases in the first year which really apply first, second, third year, which really apply to all Americans. They provide health insurance protections to all Americans, and that's the most sort of substantive area of the law that's really providing benefits. Over the next series of years, there will be benefits in terms of new reforms to the way we pay for health care. Those are experiments to some degree, but they're also drivers of large-scale reforms. And then really in 2014, that's when issues around the mandate become relevant at all, the minimum coverage provision, because that is when we are trying, the law anticipates providing coverage to people who do not have coverage today, and creates the insurance exchanges. And just to speak from the policy perspective, because I do think it intertwines with the law, I will say I did go to law school. I have not practiced law, and the law school I went to was Yale, where no one actually talked about what the law is. So my legal limits are many. But in terms of the interaction between the mandate, I would say the reason why we discussed an individual mandate and why it was an important element of what was put forward, and I will note for the record that during almost the entirety of the debate on the bill, a bill that, as many will note, had many attacks on it, the individual mandate provision was not subject to attack until very late in the process. And for those who look back at the congressional record, the Senate Finance Committee did a walkthrough on the bill that was supported by all members, Republicans and Democrats, in which they assumed an individual mandate would be in the final legislation. And I think part of that was because we did as drafters think of the individual of healthcare as different than other arenas, simply because I end up paying for health insurance that people choose not to get, in the sense that when millions of Americans, because of the federal government has established a right to health care when you need emergency services, that is a decision the federal government made through EMTALA, costs are shifted in the healthcare system. It is a very inefficient system. It is made more inefficient by the fact that people who don't have health care, we don't let them die. We actually provide health care to them, and that is what shifts cost to everyone who has health insurance. It's been noted that that cost is literally $1,000 per family, and that is why any attempt to rationalize the healthcare system starts with ensuring that everyone get health insurance. And why this has been, I would say to those who fear government tyranny, nobody actually, this is a unique case in which people really felt like because you have that level of cost shifting, it was important to rationalize the system and ensure that insurance protections like pre-existing conditions were ones that could be offered. In terms of the benefits offered, we are actually in the phase now where for the last 6 months, very important insurance protections have been put in place. And those insurance protections run from ensuring that children who have pre-existing conditions have the right to health insurance, to ensuring that people who, children up to the age, or kids up to the age of 26 can get coverage from their parents' health insurance, and important protections on insurance companies, regulations around annual limits and lifetime limits that, today cancer patients are getting the health insurance that they would not have had a year ago. And as importantly, millions of seniors are receiving benefits to be able to pay for prescription drug coverage, and millions of small businesses are receiving tax credits to be able to provide insurance to their employees. These are aspects of the law that really help millions of Americans, people who currently have health insurance, and receive benefits. And that's why I think there were a lot of legal analysts who questioned why the Justice Department would seek to clarify the judge and really threaten an actual stay on implementation. And I think it was the right decision because it was important for this judge even to see how much the law itself is already having an impact to the benefit of millions of Americans, and how those who decry judicial activism should be very concerned when a single judge in a single district chooses to overturn an act of Congress properly enacted, often by supermajorities, by a Congress representing the country as a whole.
Thank you. Forgive us, we're all trying to figure out by our smartphones exactly what it was that Judge Vinson did. It's still a little bit unclear. But I sort of want to pick up on exactly what Nira was talking about at the end, which was going to be my first question anyway, which is not just, what Judge Vinson's done, but what this whole idea of throwing this law into court, whether you believe that it's constitutional or not, has done for the view of the law by the public. We do know that this law the public is split about the law, pretty much 50-50, approval, disapproval. Republicans really, really, really don't like it. Democrats pretty much like it, although there's a lot of Democrats who wish it had gone further. So what I'm interested in hearing from the panel is, what does the view of whether it is legitimate, or at least whether the individual mandate part of it is legitimate, but I think the public doesn't really distinguish between that. And obviously when you get a decision like Judge Vinson's decision that says you can't pull apart the individual mandate from the rest of the law, what does that do to the public's view of this law, to have it kicking around in court for presumably at least another year or so?
Well, just one really quick statement. Based on the evidence of state and private parties' conduct following Judge Vinson's decision on January 31, not much. Virtually every state, including virtually every state that is involved in the lawsuit in Florida, went right ahead pocketing benefits that were provided by the law, and continuing to undertake the implementation responsibilities that they identified. As I think it was Julie said, 2 states actually said they wouldn't, they would stop in their tracks, although it's not clear they actually did. So I think that in the real world, the evidence is that people are moving forward with this law.
The government's filing before Judge Vinson when they said, surely you didn't mean that everything has to stop now. I mean, Judge Vinson has ruled that, and he's presumably clarified today, that if his ruling is affirmed on appeal, his ruling will include a ruling that the entire law goes down, but that will not take effect unless and until he's affirmed on appeal. It's important to know what the government put before Judge Vinson when they said, surely you can't mean, when you issued this declaratory judgment, that it would go into effect immediately, because there are tax credits for small businesses offsetting up to 35% of employer premium costs for small businesses that have already gone into effect. There are 20 sections of the law that affect changes in Medicare payment rates, including extensions of pre-existing Medicare adjustments. There are fraud and waste provisions. 25 of the plaintiff states have applied for and continue to seek, since Judge Vinson's ruling, federal grants to set up the exchanges. In their role as employers, even the plaintiff states and employers nationwide are already required to give an option to employees to extend coverage to their children until age 26, coverage which has already gone into effect for many families. Or is all of a sudden they too have lost nationwide their insurance coverage for a 22-year-old child because of Judge Vinson's decisions? The early retiree reinsurance program, where people retire before they're eligible for Medicare, would go down. Funding for early childhood home visitation and maternal care would go down. And when you consider the range of matters that are encompassed within the bill, it would be totally extraordinary to say that with the individual mandate goes down, all of that goes down with it. So I think that gives you a sense of how extraordinary it would be. In terms of carving out this one provision, what's interesting to me and what would make me very concerned about a partisan split is that the focus is not so much on a financial incentive to have health care insurance, which seems like an unremarkable application of the commerce regulatory power. But the whole thing rests on parade of horribles. And the exact same arguments were made against Social Security. Counsel challenging Social Security told the Supreme Court, if Congress can set an age of 65 and have a Social Security system where people under 65 support those over 65, they could lower the age to 30 or 25 years old. But of course, they're not going to do that. And similarly, the minimum wage law, if Congress could regulate commerce by setting a minimum wage of $5 an hour, logically, it could set a minimum wage of $5,000 an hour. But in fact, in spite of, Elias Omens is a great libertarian law professor, very thoughtful, and even if he were right about logic, the Supreme Court isn't going to say in its opinion, we're upholding this on the following principle: Congress can do anything it wants and there are no limits. That's not the opinion the Chief Justice will write. In fact, he will say that when you consider all of the factors about the effect of transferring $43 billion, the fact that 94% of the uninsured participate in the health care market, that 90% of the hospitalization costs are transferred, in light of all that, we have no problem holding that a 2.5% financial incentive to do this is within Congress's commerce power. We need go no further. That's what they'll say. And that's why this, as a predictive matter, I don't think the heavens will fall.
So I think 3 points, since we've diverged already a little bit from the question that was asked.
I want to answer.
I am going to answer the question that was asked, even if not everybody has done so, but I will also answer 1 or 2 points that have been raised in the process of previously not answering the question. The question that was asked for public opinion, obviously there are many different surveys. It seems to me the surveys have been relatively stable over the last year once you take account of statistical noise from survey to survey. So I'm not sure these lots have had a huge effect on public opinion so far. Maybe they've had a little bit. I do hope, however, over time that more of the public will recognize that what's at stake in this litigation is not simply the individual mandate provision as such, but the question of whether Congress will have a general power to impose any mandates of any kind. And that leads me to a couple of related points. One is, as Cy Lazarus and before him Barack Obama pointed out, there are actually many other ways to address the problem of pre-existing conditions, many of which do not raise these same kinds of constitutional problems. So it's not that it's either this or you can't do anything. The problem with this way is that it creates constitutional problems and a power for Congress to mandate almost anything else of any kind. And I think Walter Dellinger is right in the sense that the court is not going to say, well, our judgment is that Congress can do whatever it wants. The problem is they would try to point to various factors, but as I noted in my presentation, each of those factors are of such a nature that they can easily be used to justify any other kind of mandate. So it's not the specific rhetoric that the court will use, it's rather the logic of the reasoning that it will have to resort to support its decision, the logic of the kinds of arguments offered by Walter and also by the government in this case. The Supreme Court at least tries to be logical in its reasoning. Doesn't always succeed, but they try, and if they are logical in the reasoning in this case and they want to uphold the law, they will have no real choice other than to uphold it on grounds that would justify any mandate of any kind. Finally, with regard to the stay, I don't think a lot should be made of it. In particular, I don't think the stay reflects any judgment by Vince or anyone else on the question of whether the law has benefits that outweigh its costs or do not. Rather, it's fairly standard practice in this kind of litigation for a district court to stay its decision until an appellate ruling can come down. Like any other district judge, Judge Vinson recognizes that ultimately, it's the Court of Appeals which will make the final decision on this, and most likely in this case, the Supreme Court. So this is just fairly standard practice, and if he had not stayed the ruling, most likely the Court of Appeals would have. So ultimately, the real action on this is going to be in the Court of Appeals and probably ultimately the Supreme Court.
So let me actually give my view on the actual question about the political support and interest. I mean, one poll that is interesting is that a majority of Americans think that the law basically has constitutional questions around it, only really because of a series of decisions that have gotten a lot of press attention, and I don't think anyone can has any sense of determination that, like, no appellate court has decided or anything like that. It's just they're just large-scale questions that people are asking about the legislation. Despite that, I mean, there are lots of people who think it might be unconstitutional who support the law still. So that raises a question about what Americans' adherence to constitutional principles. But still, and I think ultimately, what I find as a policy person and not a lawyer, fascinating about the discourse about the law and its constitutionality is that I do believe that this is an effort by opponents of the legislation to undermine the law in the courts where they could not succeed in the Congress and did not succeed and will not succeed in the course of this Congress. And so I actually think that the proper venue for that opposition is in the political arena, in the presidential cycle, in the congressional cycle, and not using, what I believe are, and I think many believe are activist decisions to limit the proper power of Congress to make laws. But I think part of that is the reason why this is happening is because people are trying to delegitimize the law itself. And one could argue, looking at stable public opinion polling on it, despite the lawsuits, one could argue that more and more benefits have been felt by people and that it would be more popular if it weren't for these constitutional attacks. We don't know the answer to that because it's hard to prove one way or the other, but I do think the fact that the nature of the challenges have been, by and large, although not perfectly, but by and large, raised by political actors on one side of the sort of political debate versus the other raises the question about the actual ultimate goals and aims of those people who are bringing these challenges, which I think have some partisan edges. The one thing I would just say as a matter about policy, just to clarify around pre-existing conditions and connections between the individual mandate and pre-existing conditions. It is the case that states have tried to do pre-existing conditions restrictions without an individual mandate minimum coverage provision. I think most people think those have failed because they dramatically raise costs. And as a matter of policy, this is one of the reasons why I think these decisions should be made by policymakers and not legal matters. It may not be a matter of legal consequence that judicial decisions that strike an individual mandate can make us all pay a lot more for the same service, but it is a matter of policy concern that if the individual mandate gets struck, the costs to the legislation will rise, as well the fact it will cover fewer people at much more significant cost. And that is another reason why a broad spectrum of people have supported the individual mandate, ranging from Stuart Butler at Heritage to Mitt Romney to Senator Chafee, who was the first person in Congress to propose it seriously. I think, again, it may not be a legal consequence, but it is a policy consequence to pre-existing conditions and really the ability of pre-existing conditions regimes to function if the individual mandate is struck.
This is actually I'm going to add an addendum to your one of your polling questions, and then I have the next question, which is that asking what the public knows and doesn't know about this law. There was a Kaiser poll that came out just a couple of weeks ago that found that almost half the public either thinks or doesn't know that the law has actually already been repealed based on just the House vote. So there's a little bit of misunderstanding about civics amongst the public. But my next question actually has to do with just a factual question about the timing of some of these appeals and when we think it might actually get to the Supreme Court. I know that several of the appeals have been filed, but are they going to 3-judge panels? Or are they going on bank? I guess, Sai, you mentioned that one of them, there was a request to go straight straight to en banc. Do we know, which appeal is likely to get there first, or how long it's likely to take? What do we think in terms of timing?
To Walter, who actually does this for a living and with great distinction, and therefore might be someone you would want to listen to on the point. But my knowledge is that the Fourth and Sixth Circuits are scheduled for arguments before 3-judge panels in the mid to late spring. So they'd get to the Supreme Court about the same time and probably would be consolidated. But right now, I'm above my pay grade already. So Walter, what do you think about this?
Well, I know the Fourth Circuit arguments will be in both cases. One judge upheld it, one struck it down.
And just for the audience who doesn't know where these places are, you might.
Yeah, the Fourth Circuit is Maryland,
Is that
Virginia, West Virginia, North and South Carolina. That argument, both the cases are going to be argued back to back from 2 different district judges, one of whom went each way. And that argument the particular date has not been scheduled, but the court has announced that the argument will take place the week of May 10th to 13th. The Sixth Circuit argument is in the latter part of April, and I don't have the date
And that's the Michigan
with
case.
me. Obviously, the Attorney General of Virginia tried to expedite this and jump all the way to the Supreme Court, which is technically possible but was utterly unrealistic. I am not the only person. There are others in an off-the-record discussion out at Stanford, the people that watch the court, who thinks that there's a chance that this will never go to the Supreme Court. I think there's a chance that unless one of the courts of appeals strikes it down, it won't go to the Supreme Court. And the reason I think that's quite possible is to remember those attacking this have 93 federal districts from which to choose. You can pinpoint among the almost 1,000 federal judges which one you want to bring this to. The fact that they've won 2 cases and not the other 3 that have gone to judgment is in that sense unsurprising. And I think this looked like a fairly routine application of the Commerce Clause before, and the drumbeat of publicity and the number of lawsuits and the numbers of attorneys general have changed public perception about that, but not, I think, necessarily the reality on the ground.
So in terms of the scheduling, I agree with most of what Walter said. At the same time, I do think there is a high likelihood that this will get to the court for this reason, that so far the judges have split along partisan lines, and I think there is a high likelihood that that is going to continue. I think while there are a few exceptions like Charles Freed, at this point, the overwhelming majority of conservative libertarian jurists, scholars, and others believe that this is unconstitutional, and you will see this split continue in the courts. Now, I regret that there is a partisan split. I hope that some of the people who are not conservative libertarians will recognize that this poses threats and that you can have a fairly broad interpretation of congressional power without it being unlimited. But that said, I think that hope is not going to be realized in the near future, probably, except maybe after today it will be, I don't know, but probably not. And therefore, you will see this divide. It's true they can pick their district, but they can't pick their judge. A judge within a district, by and large, is usually, I think in most districts, randomly assigned. Is that right?
Not necessarily. You can tell who's coming up sometimes, but it may be that you can't do it.
Yeah. So I think that the 2 judges who have ruled against the mandate so far are fairly representative of the thinking of conservative jurists in this case, not in every single detail of every little thing they said, but in terms of their broad approach to the law. I also think, by the way, that the fact that you see this divide is an indication that these lawsuits are not frivolous in the way that was said before, that when you have issues in constitutional law which tend to split jurists along political lines, that tends to be an indication that, in fact, the precedent is not completely clear and that neither side has a slam dunk in the litigation. In cases where there really is a slam dunk, you do not tend to see divides of this kind.
Let me just say, I think we can give a precise answer, though, Julie. Assuming it does go to the Supreme Court, which I think is quite likely, as I said, not inevitable, but quite likely. I think we can tell you exactly when it'll be decided, the last week in June of 2012. No, seriously, that's not that hard a prediction, that these decisions, these cases are argued in May and April and May. The courts will get them decided, the courts of appeals, by the end of the summer. That is, before they take, say, an August recess, which means that cert petitions will be filed September, October. The court will hear argument January, February, and because of the importance of the case and the fact that I think the court will not be unanimous, the Supreme Court, they will go back and forth between drafting a majority and dissenting opinions until the very end. The very end of next year's term, which will mean the last week in June of 2012. I mean, I think you can actually pretty much put that on your reporter's calendar, not to be on vacation.
Right, Julie, right. Could I just a couple of sentences about one point that Ilya made, and it's clear that there's an ideological split around the mandate, but it is not simply a partisan split or a split between moderates or liberals on one hand and conservatives on the other. It's really a split within the Republican fold. It's a split between libertarians and mainstream conservatives. The mainstream conservative point of view on this constitutional issue, as it had certainly existed until very recently, if not still, is exactly that between people like Charles Freed and Oren Kerr and Eugene Volokh on the one hand, and people like Ilya and the two district judges that have ruled against the mandate on the other. The strongest single opinion supporting the case for the mandate was authored by Antonin Scalia in 2005. Justice Kennedy, Chief Justice Rehnquist, all of those conservative jurists have articulated a strong, strong emphasis on judicial restraint and support for Congress having options to deal with policy issues. That's completely inconsistent with the kind of arguments that Ilya is making here, although he makes them very articulately and with great sincerity. So I want to make that clear. And the choice for justices like Roberts and Scalia and Kennedy is going to be whether they stick with the mainstream conservative emphasis on judicial restraint that they have espoused their entire professional working lives, or whether they roll toward libertarianism the way the Republican Party is being driven by the Tea Party on the political level these days. And I suppose one way of looking at it is will they decide to emulate Richard Lugar or emulate Orrin Hatch?
So Orrin Hatch is not a mainstream Republican now. Is that so? It's true, I'm libertarian. I have lots of problems with conservatives on many issues. I don't hide that. However, neither of these two judges is a libertarian or even close to it. Moreover, most of the Tea Party people are not libertarians and so on. It is true that there is a small handful of conservative law professors who have come out saying that they think the law is constitutional. However, if there's one group that I am familiar with, it is in fact conservative law professors and legal experts. There's not that many of them, so I think I actually personally know about 90% of the relevant group and their attitudes, and I would say that the division of opinion within that group on whether that law is constitutional or not is about 80-20 to 90-10 against. There is, of course, a few people who think otherwise. No group is completely monolithic. And for obvious reasons, those few who believe that it is constitutional get a disproportionate amount of press attention. I can also, by the way, point to a small number of liberal legal experts who think that there are constitutional problems with it, such as Jonathan Turley. But that said,
He's been excommunicated.
Right, I was
okay, so just as Orrin Hatch is no longer a mainstream Republican, so Jonathan Turley is no longer a mainstream liberal. Perhaps people in this organization are better qualified than I am to decide who counts as a liberal. But I would say only that while it's easy to point to exceptional cases, overall this is the case. Lastly, on Scalia, in Scalia's opinion in the Gonzalez versus Raich case, he mentioned, which was referred to by Tsai, he mentioned the word activity 42 times as a limit on the range of things that is covered by Congress's power. And ever since that opinion, Scalia has more or less been working hard in more recent opinions to sort of send a signal that the scope of his logic was limited, most recently in the Comstock opinion where he sided with Thomas on an important related issue. So while Scalia will never admit it publicly, I think he, to some extent, worries that he went too far in that opinion. But even if he doesn't take back anything that he said, none of it is inconsistent with voting to strike down the mandate. For example, in that opinion, he also did not address the question of what counts as proper under a necessary and proper clause, and that's precisely the issue at stake with respect to necessary and proper clause in the present case.
Can I just say one very quick thing, which is I have to say as a non-lawyer, I mean a lawyer who does not practice and who does not pay very close attention, I find it surprising that conservatives are very comfortable with the idea of judges making these decisions and making these decisions, like the careful maneuvering we're making around, what Justice Scalia really meant in one situation. I appreciate that these are constitutional questions, but at the end of the day, what I find surprising about this entire discourse is that, traditionally it has been conservatives and conservative thinkers and conservative theorists of the law who have evinced a discomfort with judges making policy decisions around what Americans can and cannot do, and have been uncomfortable with quote-unquote unelected judges making determinations over the will of Congress and the presidency. And I believe if generally speaking, we should allow the elected branch to make these determinations. And I would feel more comfortable if the constant virulent attacks on liberals, liberal judges determining issues of equality when it comes to gay and lesbians was not subject to attack now out of the same breadth of political leaders and theorists and conservatives who are supporting judges and making distinctions about laws that were properly enacted within a year of the discussion we're having.
Go ahead.
Yeah. So, as I said, I'm not a conservative, so I may not be the best guide always to what conservatives are not comfortable with, but I would say two things. Most conservative legal theorists, not all, there are exceptions, but most have never claimed that it is generally wrong for judges to strike down legislation. What they have said is that judges should only do so if the legislation is contrary to the text or the original meaning of the Constitution. And of course, that is precisely the kind of argument that is being made here, that I think if you look at the text of the Constitution, the original meaning, we have a very strong case for our side. Now, personally, I have no problem with gay marriage. I support it. I'm not sure it's constitutionally required, but I think it's a good thing. Those, however, who dislike the idea of constitutionalizing it, some of them certainly may just be motivated by political opposition to it, but others would argue, well, if you're a textualist and originalist, it doesn't seem like there's anything in the text of the Constitution that requires that gay marriage be legal. You can argue that they're wrong, that in fact they're interpreting the text incorrectly, but once one recognizes that the issue is not some claim that judges striking down laws is generally bad, but rather whether the judges are striking them down based on the text of the Constitution or not, then I think it's perfectly consistent for conservatives to say that on the one hand they oppose judicial activism, that is activism in the sense of judges going away from the text and original meaning of the Constitution, and on the other hand they favor striking down certain laws. Indeed, I think under a reasonable definition of activism, it is just as activist for judges to fail to enforce the Constitution when it bans something that Congress has done as it is to strike down something which is constitutionally permissible. Both, I think, are going away from the required duty of the judges under a system of judicial review.
I guess I would just say we obviously disagree that this is a clear constitutional case and that the text of the Constitution does not seem to touch precisely on the issue of health insurance coverage. So I think that level of interpretation is always where you get to the question of whether we're being activist or not.
All right, well, I think it's time to turn it over to the audience. I'm just going to use my moderator's prerogative to add one little comment about the argument about Orrin Hatch. I'd point out that even though today Orrin Hatch is an avowed opponent of this in 1993 and 1994, he was a co-sponsor of the original Republican bill that had for the individual mandate. So he's been on both sides of this issue.
As has Barack Obama.
Yes, that's true. That's correct, as has Barack Obama. I would remind you, please, there's a microphone coming around. When you ask your question, please identify yourself. So, right here.
Hey, Ian Milheiser with CAP. So I appreciate the discussion of what conservative legal scholars are interested in, but I'm more interested in what conservatives who wear black robes think about this. And when I look at the Supreme Court, there is one justice whose vision is very much in line with what I see in Hudson and Vincent's decision, and that's Justice Thomas, who has very clearly said that he wants to roll back federal power. And if anything, when you look at Hudson and Vincent's conclusion that a state can defeat a constitutional standing requirement by passing a nullification law, it suggests that they were even more aggressive. But Roberts and Alito, to some extent, were put on the court entirely because the president who nominated them wanted an incredibly expansive role for the federal government. They were chosen because he thought they would uphold Gitmo. And Roberts in particular has shown no appetite for rolling back the federal role when he's been given an opportunity to do so. Look at his preemption cases. My question is, looking at the lower courts this is likely to appeal to, who are the conservatives who are more like Thomas and who are the conservatives who are more like Roberts? And do you agree with me that Hudson and Vincent are much more like Thomas than they are like anyone else?
Are you asking me or the other?
You know, I don't know the prior record of either Judge Benson or Judge Hudson enough to know. My reaction to what Elia was saying about predictions was this. At first, I was going to challenge his notion that this would continue to follow a sort of ideological line by saying that I was going to say, you know, you're a very good social scientist, and you know that 2 is an awfully small number from which to extrapolate a regression analysis. So the fact that 2 people named Benson and Hudson out of 1,000 federal judges have struck this down doesn't sort of give you a good predictive basis. But then you went on to say, I think, something that I did find somewhat persuasive, and that is that the pool of conservative thinkers, professors, lawyers, others that talk to one another have swung heavily in a certain way. And the question is whether that becomes predictive of what federal Court of Appeals judges will do is an interesting one. Sometimes that's not been very predictive. There was a time, Elian, when the sort of conservative movement decided that the next great doctrine would be the unconstitutional delegation of authority to administrative agencies. I think Judge Douglas Ginsburg had spoken of that, and it got to the Supreme Court, and they said, we're not going to get into second-guessing how much authority Congress gives to agencies. Forget about this. So sometimes those theoretical things that gain currency in the conservative pool have not wound up being predicted, but other times they have. The last time the Supreme Court had a Second Amendment case before the District of Columbia versus Heller, which I unsuccessfully argued, I should note. The last time in the 1930s, the court had overwhelmingly given a quite narrow reading to the Second Amendment. So there were no intervening precedents, but everybody knew it was going to be a very close case and probably 5-4 against, because there had been a coalescing of viewpoints over the preceding decade among conservative scholars that turned out to be quite predictive of where the courts would be. Boy, I think if we continue to follow a process where every democratically appointed judge rule one way and every Republican appointed judge rule the other way, and we get to the Supreme Court and it's 5 Republican appointed judges and 4 democratically appointed judges in dissent, I think that's a very unsettling concept. I am just not, I'm agnostic. I just don't know. I think judges may have a different reaction than scholars on this about whether we want to get into the business of deciding sort of how much is too much when there's a regulation of commerce.
So I think much of what Walter said I actually agree with.
Right.
Obviously, it's true that sort of at the Supreme Court there's a small n. So if even one justice in the block of 5 more conservative ones decides for whatever reason that he doesn't want to strike this down, then it won't be struck down, and he may be idiosyncratic relative to other conservatives, but it will still swing the outcome of the case. That said, while it's certainly true that Thomas is willing to go farther in rolling back federal power than the other conservatives on the Supreme Court, I don't think you have to go as far as Thomas to want to do so. Moreover, people like Scalia and also Kennedy in recent cases, such as the Comstock case and also Alito, have signaled have gone out of their way to signal their commitment to the idea of limiting federal power. And Alito's record on federalism on the lower courts actually was pretty strong. I agree with you, that may not be the reason why Bush nominated him. Bush clearly did not care much about limiting federal power, but noticed that Alito wasn't even his first choice for that seat to begin with. People might remember the not very successful nomination of Harriet Miers. Now, as to Roberts, it's hard to predict his position on this. I do not think it will be predicted by the preemption cases, because I think even other conservative justices often have taken aggressive positions on preemption, even as they also have been willing to limit federal power. I'm sorry?
Thomas has not.
Thomas is a rare exception on that, yes. But some of the others have. So I think it is a common belief, in my view, not really an entirely correct one, but it's common among conservative jurists that broad preemption is perfectly compatible with narrow interpretations of federal power in the Constitution. For those of you who may not be familiar with preemption, this is simply the question of interpreting statutes to see whether those federal statutes preempt state laws. And so many conservatives believe that Congress's powers are limited and should be constrained, but where Congress does have power, its laws should be interpreted broadly to preempt any state laws which contradict even in a potentially small way. I don't fully agree with that myself, but it's a common belief among conservative jurists. So lastly, as to whether Vinson and Hudson are different or whatnot, as I think an important point that Walter made is that judges are not hermetically sealed from the discourse that goes on outside. So they know the stream of opinion among conservative libertarian jurists and scholars and others, and they know it's overwhelming on one side. That doesn't automatically mean the conservative judges will agree with it, but they're certainly influenced by it. The delegation situation that Walter mentioned, I think, is not entirely analogous, because that's an issue which actually split conservatives among themselves. There were many conservatives who liked the idea of broad delegation because of their commitment to executive power, whereas other people, in particular libertarians like me and also Douglas Ginsburg, we don't like broad delegated power. But of course, we didn't agree with the conservative justices with what they did in the Guantanamo cases either. So that's an issue that splits that splits sort of right of center jurists, whereas this one, it splits them a little bit, but not down the middle. It splits them like in a 90-10 kind of a way.
And if I can do one quick sentence, I agree almost entirely with the very thoughtful summary that Ilya just gave us. And the importance of this is that these cases are about a fundamentally political revolution overtaking the courts. So what happens, as he said, what is happening off the court, outside of the courts, in terms of recognition of the radical implications of this revolution, and whether or not public opinion is forming against or in support of it, I think will have a very significant impact on what the Supreme Court ultimately decides. But all of us should understand that is really what we are dealing with here.
Next question, right here.
Bob Saginaw, member of ACS. My question to Professor Soman. Isn't it premature for a federal court to make a ruling here, particularly on the mandate aspect? We're still very much in the political activity aspect. As you pointed out, Congress, the House reversed. the Congress can switch. In 2012, we have 23 Democratic senators protecting their seats. There's a presidential election. You know, this is a political thicket involvement that courts are getting into. Why shouldn't they wait for the last practical moment to address the issue of the mandate?
Which goes into effect in 2014 is the background.
Yeah, so I would say two things. There are technical legal questions around standing and ripeness, which the government has raised to object to bring the federal government to bring the cases now. The federal government's position on that, at least in the major cases, has been consistently rejected, not just by the judges who went on to strike down the mandate, but also by other judges, and they have done so, I think, rejected for the good reason that first, the law has been passed. Whether the law continues to be politically controversial or whether it might be repealed in the future or not, I think is not relevant to, legally speaking. Obviously, it's very important politically. Secondly, as the judges have consistently noted, including the liberal judges who have struck down the law is already beginning to have effects, and even though the mandate will not take effect until 2014, both businesses and individuals have to adjust their practices to begin to take account of it, of the fact they'll have to get either insurance that they didn't have at all or more insurance than they had before. I will say lastly that there's sort of an irony here in that over the last 30 years, by and large, it's been mostly conservatives who have argued, well, there should be restrictive standing rules to make it hard for people to get into court to raise constitutional issues, and liberals who have argued the opposite. The litigation positions in this case have sort of been flipped, with the liberals arguing for a narrow standing rules and the conservatives arguing for the opposite. Personally, I've always favored broad standing rules. I think the Constitution actually as such does not restrict standing in anything like the way the Supreme Court, much less various conservatives outside the court, have said it does. But I think in the course of litigation so far, it's been pretty clear, I think, that these sorts of standing or ripeness requirements are unlikely to stand in the way of deciding it. I guess the last thing, I do not believe that judges can or should be able to refuse to hear a case merely because the law is controversial or because it might be repealed. I think if a law has been enacted by a legislature and people challenge it, then the judges must assess those legal arguments without regard to whether the law might potentially be repealed or whether there's political controversy about it.
Question over here.
David Sobelson. A nice little precedent for the impact of the bar and the academy on decisions by federal courts is the birth of what's now called substantive due process in the late 19th century, which you may all remember was rejected regularly by the Supreme Court until after about 15 years of agitation by law professors and lawyers. The Supreme Court started striking down economic regulation on the grounds that it violated our liberty rights. But I actually had a question for Professor Soman. You mentioned that not buying health insurance is not commerce, and not buying health insurance is only within one state, but not buying wheat is not commerce, and a guy's farm is just in one state. And a case that I can never hear anybody talk about is Wickard against Filburn in the 1940s, when the U.S. Supreme Court upheld a restriction on how much wheat this guy could grow on his own farm and essentially compelled him to buy wheat in the market. And I'm wondering how your side is distinguishing that case.
I'm glad you brought that up. I always enjoy talking about Wickard versus Filburn, which I've written about extensively in my academic work. I think the answer is simple. It's true, not buying wheat is not commerce, but operating a commercial farm is certainly commerce. It is true that it might be commerce only within one state, although in the case of Mr. Filburn, actually what he was doing was growing wheat to feed to his hogs. Then very unpleasant things would happen to the hogs, and many of them would then be sold actually even in interstate commerce. So the law in question, it applied to commercial farming, which certainly is economic activity, and actually it didn't compel anybody to buy any wheat. All it said was that there's limits on how much wheat you could grow, and then you could continue to decide for yourself whether that amount of wheat that you're allowed to grow was sufficient for it, whether you wanted to buy more. So I think personally, Wickard versus Filburn is not a decision I'm a fan of. I think it was wrongly decided, but I also think it is very easily distinguishable from this case because it involved the regulation of actual economic activity. What would be more parallel to this case is a regulation which said, well, there's not enough wheat being grown, so we're going to compel ordinary people to start being wheat farmers and growing wheat and selling it in interstate commerce. That, I think, would be analogous to this case, but Wickard versus Filburn is not.
I meant to ask this before, but why do you think insurance is not an interstate issue?
It depends on what you mean by an interstate issue. So I think that actually buying health insurance would be commerce, albeit not necessarily interstate commerce. But not buying health insurance is not commerce, or rather the state of not having it is not commerce.
Okay, so you do believe that insurance itself, like purchasing insurance, is an interstate issue?
It is commerce. It is whether it is interstate commerce depends on whether you're buying the insurance across state lines or within a single state. But there's no question that it's commerce, and there's also no question under current Supreme Court precedent that it could be regulated even where it's commerce within a particular state as opposed to commerce across state lines.
Okay.
So, Ilya, what is the point of this whole elaborate discussion about whether or not insurance or these insurance transactions or decisions to buy or not buy insurance is interstate in character? I mean, under contemporary post-1937 Commerce Clause jurisprudence, and Walter and I would certainly maintain under Chief Justice Marshall's view, this is commerce that concerns more states than one. And so why go through this business about whether you can only buy an insurance policy within your state? It's still part of interstate commerce for constitutional purposes, isn't it?
Well, it is under current precedent.
Thank you.
I personally think that much of that current precedent is wrong.
Thank you.
But we don't have to reach that precedent to decide the present case. Even if you say it's perfectly constitutional to reach commerce of any kind, it still doesn't follow that it's constitutional to reach things which are not commerce, whether interstate or otherwise.
Can I say a word about precedent? Yeah, it is said that the Act, its requirement is novel and unprecedented, which is true in the sense that we usually used to use government single-payer approaches like Medicare and Social Security, so using a market system is new. But what strikes me as novel and unprecedented is the notion that the court would strike this down. For the better part of a century, the Supreme Court has not struck down any act of Congress as being beyond its powers, except for United States versus Lopez, United States versus Morrison, both of which involved a congressional attempt to regulate matters that were local and non-economic. Why? Because members of Congress like to vote against local crime. It's a great thing to vote against. So there was sort of an add-on. So they voted against guns in schools and violence against women. And it's local economic activity. So when the court later is dealing with the regulation of the home consumption of marijuana in Gonzalez versus Raich, a decision with which Ilya firmly disagrees, the court said, where the act under review is a statute that directly regulates economic commercial activity, our opinion in Morrison casts no doubt on its constitutionality. Now, Ilya would point to the word activity, which is just a fact about the case. But the key words are economic and commercial. This is a regulation of an economic commercial activity that imposes a financial incentive that's less than the, quote, incentive imposed by the Social Security law. So that it seems to me that in that sense it is entirely unremarkable and doesn't cross any line into the regulation of personal liberty. It doesn't require people to use or not use contraceptives. It doesn't require people to eat broccoli or exercise, matters which are controlled by the Liberty Clause. And if it is said that merely requiring people to purchase something is not sufficient when it's a sufficient connection to commerce because it's an affirmative activity, affirmative imposition, which is what we're talking about when you use, quote, the word inactivity. It's an affirmative obligation. Then there's such a substantial nexus of this to a $43 billion transfer in the national economy that's why I think it's, in that sense, an easy matter under the precedents. Caroline has a question or a point or wants us to stop.
No, I want you to keep going. This is terrific. Caroline Fredrickson with ACS. I guess we've talked about it or around it several times. I guess I want to go right to it. Social Security. So, Ilya, I don't mean to pick on you, and you are
I actually wanted to answer that question.
Okay, good. Well, you come into the lion's den, and we're so glad you're here. But I mean, I guess I would like to hear from the panelists. What is the applicability to Social Security, Medicare, anti-discrimination laws? We heard the slippery slope from the conservative side in terms of where the mandate could take us in broccoli and everything else. But what about the slippery slope of our fears on the liberal side of what the precedent would do to strike this down?
The easy answer is it would do absolutely nothing. With respect to Social Security, unlike this law, it actually is a tax. Why? Because it directly targets your income and says you must pay a certain percentage of your income into this fund that the government has created. Medicare works in a similar way. And so on. On the other hand, for the reasons elaborated not just by me, but several judges, including liberal ones, this is a penalty rather than a tax. With anti-discrimination laws, I would say two things. One that's about the precedent, and one that's about my own view, which, as I have noted several times, these are two separate things. With regard to the precedent, all of the anti-discrimination laws which have been upheld by the court, and to my knowledge, actually all of the anti-discrimination laws that exist in the world, whether they have been upheld by the court or not, target people who are engaged in pre-existing economic activity, operating a hotel, being an employer, operating a business, and what they say is if you engage in this economic activity, which is economic in even the narrowest possible sense of the word, then you must not discriminate along certain criteria, race, sex, or whatnot. What would be more analogous to the individual mandate is saying, well, we feel there are not enough hotels or not enough employers, so you must start up a business or start up a hotel in order to improve the national market, because that would have that would stimulate the economy perhaps, or make interstate travel easier or whatnot. So I think these cases are easily distinguishable. The last point that I would make is that I think with many of the anti-discrimination laws, a better constitutional grounding for them than a commerce clause would be Section 5 of the 14th Amendment, and I would have preferred that the court had used that approach to uphold them rather than the commerce clause, but that's perhaps a discussion for another time. Even if you think that the Commerce Clause is the right head for those, the current precedent easily allows for it, and also would allow any likely decision to strike down the mandate would allow for it as well. Because I think the word activity is not just incidental to Morrison and Lopez. It has been there in just about every Supreme Court case that addressed the Commerce Clause for many decades now. So it is a standard, it's not a legal formulation I invented. I actually don't like the formulation, but it is one that's definitely there in the precedent.
And if I can just comment on Ilya's, again, very articulate answer to Carolyn's question about the slippery slope on the other side. Obviously, if Ilya and people who agree with him prevail in the case of the individual mandate, then most of the people in this room, certainly Carolyn and myself, and people who we sympathize with, are going to be in court arguing for his narrow interpretation of that decision with respect to all of these statutes that will, in fact, be challenged. People with whom he is often in agreement probably will not be arguing for that narrow interpretation, and so the question will become, over the years, whether a narrow interpretation or a broader interpretation will actually become the new law of the land, because we will be in an entirely different constitutional universe, arguing from entirely different constitutional premises if this decision goes that way. And on the Social Security point, Carolyn, I would just say that in point of fact, although they're operating under the Commerce Clause rather than the Due Process Clause, what these cases quite clearly do is bring right back into constitutional discourse this business of trumping otherwise valid statutes with personal liberty interests. And logically, if the personal liberty interest that is really driving the allegedly Commerce Clause analysis in the mandate case, logically, if that's enough to trump the mandate as an exercise of the commerce power, it's also enough to trump it, and in fact it has as an exercise of the tax power. It is also enough to trump the Massachusetts mandate law, and it's also enough to trump an exercise of the tax power. Whether that would happen the next week after this decision comes down, I think quite clearly it wouldn't for political reasons. But the principle would be let loose out there. And the question about how far that principle will travel and how fast will be determined by politics.
Well, I was hoping to get one more question, but it is 2 o'clock, so perhaps our panel will stay for a minute or two if the last few people who couldn't get their questions in would like to come up. And thank you so much. I think this has been a wonderful.
You did very well, my friend.
Thank you.
Very well.